We talked early on about how these issues are not only important in their own right, but how they need to be connected to other issues that people care about if we're going to have any hope of how to win here. And that's why we are very excited to put together a really, really good panel here for you to take us through the rest of the morning. And it's going to be led by Marissa Brown, who many of you may know as the Executive Director of the Democracy Initiative, one of the most powerful new forces on the scene today for reform. She oversees their development, she coordinates resources, she helps create long-term strategies. Their work is astonishingly important for everything we're all going to be doing in the coming years. She before that I should say, was Executive Vice President of the Alliance for Justice, directing advocacy and public education there, including their work to ensure a fair and impartial judiciary. So in addition to all the work that she's done in her career as an organizer, she actually knows our issues, which thrills us when therefore she's helping run the show over the Democracy Initiative. So please join me in welcoming Marissa, who will then introduce the panelists.
Well, thanks, Bert, and thanks to Justice at Stake for organizing this conference. And thanks to all of our diverse panelists. We have a very diverse panel with representing lots of different organizations and constituencies. The panel is really about highlighting the work that all of these organizations are doing around the courts, but also highlighting for some of the panelists some of the work that you're doing. All right, this is going to be audience participation. We expect at the end of the panel you will have a good sense of how to engage with these organizations or groups like them in the states in which you work. And we expect our panelists will learn a little bit more about how you're working and who you are already engaged with. And we're going to start with some introductions. Because we have a lot of people on our panel, I invited everyone to introduce themselves and tell us a little bit about how the work that they are doing intersects with the state courts movement and how state courts are affecting their work. And I don't know, I guess we'll start with Raquel down at the other end there.
Well, good morning, everybody. My name is Raquel Teran. I am the State Director for Mi Familia Vota in the state of Arizona. And I come here more on the organizing perspective. We engage Latinos in the decision-making process through registering people to vote and ensuring that folks who are eligible to become citizens do so, and of course that they come out and vote. Mi Familia Vota in Arizona has been playing a critical role in fighting bad legislation, such as Proposition 200, which was passed in 2004 with the intention to curb illegal immigration. However, what we've seen is it's impacted more the voters. And the reason why I bring this up is because we've gone through a process of courts through this proposition. So we've seen how people, including Latinos, are affected by this type of legislation. For instance, there were 30,000 people who were rejected from being eligible to vote until we received the struck down of the Supreme Court in 2012. This was passed in 2004, and until 2012 we were able the Supreme Court struck down this proposition. So we see it on voting rights. We see how our families are being affected, especially in the counties of Pima, Pinal, and Maricopa County. We can talk shortly about Sheriff Arpaio, for example, who stops people for broken taillights and then have to come through to be in front of a judge. So we're very mindful that whoever is going to be, whatever judge is going to be, when people come in front of a judge, this person can have the opportunity either of keeping families together or separating a family. So we're very mindful of what's happening in Maricopa County, Pima County, and Pinal County.
Eric?
Great. My name is Eric Lesh. I head up the Fair Courts Project at Lambda Legal. Lambda Legal is the oldest and largest national legal organization working to achieve full recognition of the civil rights of LGBT people and those with HIV. And our Fair Courts Project works in three main areas: to preserve judicial independence, to promote judicial diversity, and to secure access to justice for our community. So I think I wanted to give three very quick examples of how we work in each one of these areas and why it's central to our mission at Lambda Legal. So with respect to judicial independence, it's hard to talk about the harmful impact of special interest money and politics in judicial elections without mentioning the retention election in Iowa in 2010, where three well-respected justices were removed, ousted from their positions for a unanimous ruling in Lambda Legal's Varnum lawsuit, which struck down the state's marriage ban and extended the freedom to marry for same-sex couples in Iowa. As a result, anti-gay groups, right-wing groups launched an outright attack on the judges in an attempt to punish them and to intimidate not only judges in Iowa, but across the country. And their message was clear: rule against us and you will be next. So it was important for us to not allow groups to bully us. We will continue to bring cases on behalf of LGBT people and those with HIV, but at the same time, we recognized that it was very necessary to educate people about the role of the courts so it couldn't be distorted, and to celebrate decisions like the Varnum decision as those decisions that are appropriate for courts to make, where they safeguard the rights of minority populations from the will of governing majorities. With respect to judicial diversity, judicial diversity helps strengthen public confidence in our courts. It helps promote and preserve the quality of justice. And with state courts deciding cases involving LGBT people across the country, there's every reason to demand that our community doesn't continue to be significantly underrepresented on the judicial bench. So in Puerto Rico, when the Chief Justice of the Puerto Rico Supreme Court stepped down, he said one of his biggest regrets was a decision involving interpreting the Puerto Rico law to prevent transgender individuals from amending their birth certificates to properly reflect their true identities. So Lambda Legal urged the governor to make an appointment that would reflect not only the diversity of Puerto Rico, but also the someone who would uphold the rights of LGBT people. And just last month, the governor nominated and the Senate confirmed the first out lesbian on the Puerto Rico Supreme Court. And finally, with respect to access to justice issues, LGBT people and those with HIV continue to face overt discrimination and bias in the legal system. And I can think of no better example to highlight how bad this is than Roy Moore, who's the Chief Justice of the Alabama Supreme Court. Roy Moore in 2002 wrote an opinion involving gay parents where he called gay relationships and gay people immoral, detestable, a threat to the fabric of our country. And then he campaigned for a marriage amendment in Iowa. He campaigned in 2012, demagoguing LGBT people. He actually is the president emeritus of a group that's involved in the federal lawsuit challenging the state's marriage ban. So it's hard to picture that LGBT people in Alabama think that they can trust their state court system, that LGBT litigants think that they're going to get a fair and impartial ruling from their state courts, when the head of their court system is Chief Justice Roy Moore. So that's a little why we work on all these issues.
Mike?
Hi, everyone. My name is Mike Petro with the Committee for Economic Development. I want to thank Bert Brandenburg and his team for putting me on the largest panel I've ever been on for the longest period of time. I think we're going to be here for 2 hours. Maybe we'll get a cupcake for dessert or something like that. I do represent the Committee for Economic Development, a group of business leaders, some 200 executives from around the country, who weigh in on a host of various domestic and foreign policy issues. And the question might be, why would a group called the Committee for Economic Development take on the issue of judicial selection reform? Well, first, let me tell you a story. Back in 2001, when our Policy and Impact Committee was meeting to decide on what would be the next issue CED would take on, This group of executives, 12 to 13 executives from across the country, come together once a year to decide on our issue portfolio. In the middle of that meeting, one of the issues that came up was judicial selection reform, and a member of our task force got up and had a message that he had to take, and he left the room, and he came back about 20 minutes later, and he was smiling, and it's just as we were getting into the discussion about this issue, he said the message he had was from the campaign of a judge in his home state, a judge who was very important to his company, by the way, asking for money. And so it really kind of became exhibit A of what the problem is here and why business really needs to care. So we got involved in this issue because of, one, the political nature that these campaigns are taking, and two, because of the amount of money that's flowing into the system. Thoughtful business leaders know, and they get the fact, that a fair and impartial judiciary, one that's even-handed, one that's consistent, is good, and it's an essential ingredient for not just a free society, but for also a free market economy, and I think that's really, really important to get. These bitter-fought campaigns, these campaigns that pit one group against another, it's not good for our country, it's not good for the states, it's not good for business. You know, between 2002, I believe, and 2010, Chamber of Commerce surveys were consistent across the board when they identified that 7 of the 8 worst litigation environments were in states that had these types of elections that are politically charged, and again, states where there's a lot of money flowing in. So I'm pleased to elaborate further on the work that we do, but here representing a group of thoughtful business leaders that care about the judiciary and care about what that means for our economy and what that means for our country. Thanks.
Thank you. Kathy?
Good morning. I'm Kathy Duvall, and I'm with the Sierra Club. And there's the mic. The Sierra Club is, we're 122 years old, and we got started as a hiking club, but really quickly transitioned into an organization that did public education and advocacy around conservation issues, and then ultimately around protecting our air and our water and our land. The Sierra Club has a significant legal shop, both internally, and then we work with a network of about 500 environmental lawyers around the country. And there's sort of 2 major areas that our legal shops are focused on. One is around enforcement, so enforcement of the Clean Air Act, of the Clean Water Act, around hazardous laws in our country, and that we can, at the state level and at the federal level, we've done a great job of passing these laws, but then it's just completely violated by people out there. And so the way that we've really made progress is the ability to then have citizens engaged in that enforcement of those laws. And the second piece that's becoming more and more important to us as there's less progress being made in Congress is that the states and the White House are starting to move environmental policies. So when we think about how is it that we're going to address climate change, we're not actually looking for significant action coming from the Congress. We're looking for action coming at the state level, and we're looking for action coming out of the White House. Well, every time there is a rule that is made, the industry takes that and goes to court to challenge the legality of being able to do that. So the Sierra Club actually hasn't been very engaged in court issues, but over the last couple of years, we've looked at the role that the courts are playing in what we're doing, both at the state level and at the federal level. We believe that we need to move into this space if we're actually going to be successful in addressing the issues that we need to. So I'm very excited to be here today and learn from you all about places that we might be able to plug in and be helpful.
Great. Joteka?
Good morning. My name is Joteka Edie, and I am with the NAACP. The NAACP, we're the oldest and largest civil rights organization in the country. A little bit, tiny bit younger than the Sierra Club. We're 105 years old. And I would note that this is the second largest panel that I've been on, because last week I was on a panel with 12 people. So, and it was just as longer and longer. But the NAACP, throughout our history, the courts has played a major role in our history of our institution, whether it has ranged from the work that we've done as it relates to a number of cases we're most famous for, Brown v. Board of Education and where those cases started, or to some of the more recent work that we've been doing in the area of democracy, both in the state and federal courts, but focusing on the state courts. We had a major victory in Wisconsin and in Pennsylvania as it relates to the fight against voter suppression in the United States. And so the NAACP sees, and we have units and branches all across the country. We're in all 50 states, and we have a large presence in communities everywhere. And often we are in litigation everywhere. We feel currently, to this date, that the threat on democracy is one of the greatest threats that we're facing in more than a generation at the association. Number one, because we feel that the ability to fight and our ability to advocate for any issue that we care about, whether it's education, whether it's the work that we do around criminal justice or health advocacy, or protecting the climate, our climate change work, or if it's any other area, we do that through the ballot box. And as long as we see this aggressive attack on voting rights, then we need to have a fair and impartial courts, because what we're beginning to see is when you can flood money into the judicial process, what we begin to see is biased opinions that come out that are not in the interest of the people. And so the association has really at the state level been very invested in fighting a number of fights as it relates to democracy through the courts. And we advocate for fair judicial process throughout the nation. Additionally, we've done a lot of work in the area of criminal justice. My former colleague, Diane West-Kearney, will probably speak more on this. But we've seen what happens, I think very similar to my colleague who spoke earlier, is that particularly in the life of African Americans and African American men in particularly, we face a lot of courts, and we find ourselves in front of judges often. Those judges make a decision, they have a lot of discretion on what happens. In some cases, and I know Diane will speak to this, is in who lives and who dies. In other cases, you know, what happens and can change the trajectory of one's life forever. And that's very, very important. I mean, we deal with the issue of felony disenfranchisement, something that's very important. There are 4.4 million people who serve their time, who have a felony conviction and cannot vote in this country because of their experience with the court system. And so I think when we look at the holistic quality of life, whether it's your ability to access a ballot free and fair in this country, or whether or not it's the discretion that a judge would have when you come before that judge, whether or not, you know, you will live, you will die, or your quality of life will change forever, the courts is always there. And that's why it's so vital to the NAACP and all of our colleagues that we have a fair court system, because justice has to be fair. And I think that's what we've stated, and the work of the NAACP has been for the last 105 years. And I think that even more so in this time, while much has changed, much yet still remains the same, that we must continue that work of seeking a fair and impartial judicial system.
Great. Elise?
Hello, good morning. I'm Elise Hogue, and I am the president of NARAL Pro-Choice America. I have been the president of NARAL for about 16 months. I don't come from the reproductive rights sector. I actually came to the reproductive rights sector after spending 6 years at MoveOn.org, running our political advocacy and communication shop. So my orientation is very much as an organizer and a strategic communications person, and thinking about how we create engagement opportunities at all level of civil society for people's rights to be affirmed. I can't ever do a panel on the courts. We're only 45 years old, so we're, I guess, babies on the panel. We just turned 45. And I can never talk about the courts without quoting my friend Nan Aaron from Alliance for Justice, who taught me when I was at MoveOn that the right sees the courts as a pathway to power, while the left sees the courts as a pathway to justice. And I think that this speaks volumes about how we found ourselves where we are right now. NARAL, long before I got there, has had a focus on federal courts, even though we don't litigate. We see ourselves as an organizing and communications arm around the litigation that's done in our sector very effectively. But I will say, our base, which is quite significant, in fact, 7 in 10 Americans affirm that they believe in the rights enshrined in Roe, which is a really important question because the way people get asked whether they're pro-choice or pro-life or any other term you want to use tends to be all over the place. But 7 in 10 Americans consistently affirm the rights upheld in Roe, which is critical to this discussion because it's a legal framework. It's not a moral framework. And in fact, there's a large number of people who say, abortion is immoral, I wouldn't do it myself, I wouldn't want it for my family, but I do believe it should be legal, which is the question that we should be litigating in the courts. It's not, however, the question that we are litigating in the courts right now. And I think our base need look no further than Hobby Lobby to see how the third branch of government actually will play politics with women and families' lives. People forget that the decision Hobby Lobby, the decision that came down in the Hobby Lobby case affects men too. Men who work at Hobby Lobby who are covered by their insurance no longer have access for their wives to these particular kinds of birth control that they were objecting to. But I would say, and I've told people in the press and allies, Hobby Lobby for us was the culmination of the outrage with the courts, not the source of it. And we saw deep engagement on 2 campaigns we've run since I've been at NARAL. One continues to be stopping the federal nominee Michael Boggs from ascending from the Georgia State Court to the federal district court out of Georgia. This is a man who voted when he was in the state legislature to publish abortion providers' name and addresses on the internet at a time where clinic violence was very high, voted to enshrine a marriage equality ban in the state constitution, and voted twice to fly the Confederate flag above the Georgia State House. And so he ran on his legislative record. He ran on these values for state court, and now we're seeing him ascend, but hopefully not, to the federal court. We're actually doing pretty well. We have 12 senators actually opposed to his nominee at this point, and many of my allies on stage have signed on to this campaign. But what I will say is that our members, because we are so highly aware of the role that the courts play, have been deeply engaged on this nomination. The other one happened, and I was actually surprised by this, in Nebraska early in my tenure at NARAL, where a state court judge had denied a minor her constitutionally guaranteed access to abortion. She came from an abusive home. She found herself with an unintended pregnancy. Nebraska is a judicial bypass state, which means if you can't go to your parents, you have to go to the judge. The judge, before she ever opened her mouth, said he was not going to grant this because she would be killing the baby inside of her and she was not mature enough to make this decision, although presumably she's mature enough to become a parent. We had over 90,000 petition signatures to ask that the state judge be censured for putting his own personal ideology above the rule of law. And that's really important, right? Because we're not actually saying we don't believe that you have a litmus test on issues. What we do believe is that we work very, very hard for values to become bills through people we elect, bills to become laws that support our equality and justice, and the courts is where those laws get turned into rights. It's where the rubber hits the road in terms of each individual being afforded what their constitutional rights are. And in my field, we are definitely seeing state laws actually start to chip away at constitutional rights, and state courts being in an incredibly important position in upholding the constitutional rights, or these judges putting their personal ideology ahead of the Constitution. And I think we're in for 10 or 20 years of litigation on reproductive freedom. The state, we passed 53 different state laws just this year alone that chip away at Roe. So the state courts are a place that we're starting to look at around engagement and communication and getting people to focus on the fact that the third branch of government is incredibly important in achieving our values in society.
Great. Mark?
Good morning. I'm Mark DeSetti. I'm the Director of Legislative and Political Advocacy for the Kansas National Education Association, our state teachers union, and I'm pleased to be on the Unusual Allies panel up here. It's interesting listening to everybody talk because this issue, if you're a hard right legislator pushing this issue of politicizing court appointments, there's so many reasons for them to do this. Chris Kobach is our Secretary of State. We are the birthplace of the Summer of Mercy anti-abortion movement. We have a couple of businessmen in Wichita who may not be friendly to the Sierra Club. We're all on the same thing. There's so many goals in Kansas wrapped up in our governor and the hard right legislature's move to eliminate merit selection of justices, whether that is abortion rights, whether that is upholding the state's ban on same-sex marriage, whether that is upholding the voter suppression actions of our legislature and Supreme Court. But primarily in Kansas, the reason the education community is on this is because it has new energy since courts have been ruling since about 2005, and again this year, that the state legislature is not meeting its constitutional obligation to fund public education, that we are dramatically underfunded in public education. The court continues to rule against the state, and you can't have, if you're Governor Brownback, the elimination of the state income tax, nearly half of our state revenue, and meet a court order to meet your constitutional obligation to fund schools. And so you have to work very hard to get a court that will not rule in favor of funding schools. And they've been trying this for several years, but fortunately, up until recently, we've had majorities in the legislature, a pro-public education majority in the legislature made up of traditional or moderate Republicans and Democrats that have held the governor at bay until the last election, and now we're getting closer to the point where the votes are there to push through a constitutional amendment. I think Ryan mentioned that our merit selection for the Supreme Court is enshrined in the Constitution. They were able legislatively to undo that for the appellate court. So we're in this fight because we want to preserve public education in the state of Kansas. And these same anti-abortion, anti-wind energy, anti-voter rights, anti-rights for LGBT citizens are also anti-public education. They also want to defund public schools and turn that money over to religious schools and private schools as quickly as possible. So we're in the fight for these same reasons. The other fight for us as a union is they are also anti-labor union and have passed a number of measures to harm union workers, particularly public sector union workers in the state of Kansas, with the intent of doing away with essentially our PAC, which is one of the largest PACs in the political action committees in the state of Kansas, and is funding or trying to fund a majority of this work on the progressive end and trying to help our allies in the bar and the League of Women Voters and so on to preserve this court system. So it's a real struggle, and we're delighted to be working with such great people as Ryan and Callie from the Kansas Association for Justice, League of Women Voters, and a number of other unusual allies to preserve our merit system in Kansas.
Great.
Good
Diane.
morning. I'm Diane Russ Tierney. I'm the Executive Director of the National Coalition to Abolish the Death Penalty. And as Joteka said, we are First of all, let me say we are probably the baby, believe it or not, on the panel. We were 37 years old. We were founded right when the Supreme Court ruled in Gregg versus Georgia that the death penalty, in theory, could function in a way that was consistent with our Constitution. And at that time, a coalition of civil rights leaders, religious leaders, civil liberties leaders came together and formed an organization that was at that time thought to be one that could just cry out in the wilderness and say this is wrong. There had to be a voice of opposition. And they had the vision that they also wanted to establish affiliates, state affiliate organizations around the country. These are independent organizations around the country, and they too were a voice of opposition. Over the last 37 years, those organizations have transformed themselves into the engine, along with the Capital Defense Bar, that has been working to end the death penalty, stopping execution state by state, and moving policymakers to actually repeal the death penalty. And I would be remiss if I didn't call out two of our former affiliate leaders who actually repealed the death penalty in both their states, New Mexico and Illinois. Jeremy Schrader and Vicki Harrison, now with Common Cause, who were among the leadership that has been moving in the country to end the death penalty. And so that's who we are. And as we've said, our interest in the courts is the fact that they've been literally determining life and death, and state court judges in particular. And I wanted to highlight three examples, and one that you probably heard about, which was notorious last week, which was the 2-hour execution in Arizona. We need to talk. And that was the direct result of not only the arrogance of the state officials, but the lack of oversight that the courts have been providing in these cases, because the reason that we had that botched execution in Arizona was because of the secrecy and the lack of oversight that the government officials insisted on over the objections of the lawyers who said, tell us where you got the drugs, tell us who made them so that we can figure out whether they will actually work, whether you actually know how to use the drugs. And the courts failed, up until including the Supreme Court, to overturn the state's argument that secrecy should rule the day. But the real story behind that, and I think one of the more sort of graphic examples of what you're wanting to talk about today, is what happened in Oklahoma, which was where we saw literally a constitutional crisis at work. In Oklahoma, there's a two-court system, as I understand it, where there's the civil court and the criminal court, and the criminal court had already refused to overturn that state's claim to secrecy, that we don't have to tell you where we get the drugs from, we don't have to tell you how we're going to kill your client. The public doesn't have to know these things. But the civil court in that system said, yes, this is a First Amendment violation. And so for a while, the news was about the courts fighting. The criminal court saying, oh, you are way off base, you have no jurisdiction here. But then the news changed when the governor of the state, Governor Felon, says, wait a minute, I'm not bound by what the civil court says. You know, we're going to go forward with this execution no matter what, which is enough, right? But then it gets worse. A legislator in the legislature decided, I'm going to introduce legislation to impeach the 5 court justices that ruled that there should be a stay in this case so that the public could find out what drugs were going to be used. A lot of back and forth. Extraordinary. Not surprisingly, the courts caved in to that extraordinary pressure, and the execution proceeded. And in that case, we thought the worst that could happen would be the man would die 45 minutes after an execution from a heart attack. We had no idea that Arizona was going to follow. But that kind of pressure on courts is undermining not only the rights of individual defendants, but the right of the public to know. And so there are journalists raising these questions in Missouri. And so the other example I want to throw out is a case that you ought to look at is Woodward versus Alabama, and read the dissent of Justice Sotomayor, where we look at judicial override in Alabama. Now, there are a number of states that allow judges to override the decision of a jury on the question of whether a death sentence should be imposed. But Alabama is the only state at this point in time where I think that where the judges are consistently overruling these decisions by the jury, and we know the jury is supposed to reflect the sentiment of the public in Alabama, the judges are overriding these. And what Justice Sotomayor points to is a report done by the Equal Justice Initiative of Alabama that shows that there's a statistically significant relationship between the rate of jury overrides in favor of death and elections. And they were able to actually also point to judges in election years who actually touted their support of capital punishment. So we are in this fight and want to get more engaged because we see how the death penalty in particular is corroding and adding to and contributing to the problems that we have in terms of assuring fair administration of justice. The last thing I'll say is this. One of the things we've done is we've started a campaign called the 90 Million Strong campaign, which is meant to mobilize all the public, all the people who oppose the death penalty. And for a very long time, the thought has been that somehow that was a politically weak position to be in. But there are 90 million people in the United States, based on the polling, who are concerned about the death penalty, who believe it's unfair, who are prepared to get engaged in this. And we're at the beginning of doing that. And so part of the real tragedy here is that some of these political calculations about where we need to be that are so perverting the quality of justice are not even based on reality. The reality is that people are not voting against people because of their opposition to the death penalty, and it's not clear that people are voting for people because of their support. So these judges that are campaigning and making decisions based on some perception are making it on the basis of wrong information. So we've got to mobilize the public and let them know that the public wants fair justice. So we're so excited to get involved in this fight, because at the end of the day, we believe if you have a fair judge looking at the facts, we will see an end to the death penalty ultimately, but certainly more justice in these cases.
Great. Well, we have, as I said when we started, we really have an array of panelists with really different perspectives on this issue. And one of the things I was really struck by as everybody presented is we have some people on this panel who represent membership organizations who really are spending a lot of their time thinking about how to talk to people who may be concerned about climate change, about things like fair courts. And we have some people who are talking to and educating their constituencies. And so, Diane, I want to start back with you, although you just finished. You just talked about the 90 million strong. How do you educate people about this? How do you start from people who may or may not know the first thing about the courts? And the other thing I was thinking as we were going through is just also, there are a couple lawyers on this panel, but most of the people on this panel are actually not lawyers, which I actually think is great, because I think it definitely, as the last panel suggested, is helpful sometimes to know what the legal frameworks are and know what the law says, but it's also important to be able to start where the people we're talking to are. So tell us a little bit about that and how you're thinking about educating all those people.
Well, I think
or who are already there, maybe.
Well, I think the first thing we have to educate people about is that they can have impact. I think that what we found is that we have people who agree with us who don't know quite how to plug into the system. And so I think, first of all, educating people about the importance of getting engaged, the importance of being part of these discussions, the importance of challenging, I think, publicly when we see elections where people are using any of these issues as litmus tests, to say that's not what we're looking for, to start articulating in letters to the editor and town halls that we're looking for judges who can be fair, who are not coming with any preconceived notions. We're going to look at that. I think that's a key piece of it. And then I think it's about creating opportunities for people to connect. So we're doing a lot through social media. We're looking to build alliances with other organizations, and so that our issue and other issues sort of get to be part of the conversation. So I think it's about, first of all, telling people and educating them and helping them understand how that they can have an impact. And the second is giving them the tools to be able to connect. So I think getting more people talking about these issues and talking about it, I think the value of this kind of panel is that each of our constituencies sees how this issue affects us, and it's taken out of the context of some kind of the courts over there, but how this affects my rights. And so I think that's the kind of thing that we can use to empower people and encourage them to do more.
And Mark, I was going to ask you, because you actually talk to legislators, how do you talk to them about this? How do you represent, you're representing educators, and you're saying, we care about this. What are you telling them?
Well, I guess you first of all have to look at your legislative body and divide them up into which ones you can talk to, which ones are worth talking to, and which ones you can just go and say thank you to. We pretty much have our legislature divided that way, and we can look at them, and that's the advantage of working with so many allies in so many coalitions, and working with other labor unions, and working with Kansas Association for Justice, and working with League of Women Voters, parent organizations, and so many others. We all have interactions with these people, and we can all pretty well determine, you know, when we sit down and say, okay, what's your list of targeted legislators? Pretty much we're all the same. Whether you're with the LGBT community, whether you're with the pro-choice community or anything else, it's pretty much the same people we're talking about. So we can divide them up and look at them that way. And in talking to them, what we really need to focus on are these, we need to take the issue that is most pertinent to those, what I might call swing legislators, and frame it in that way. So in my case, when we talk to legislators about education funding, education issues, we can frame this argument based on the only reason to make this change is because because somebody does not want to fund schools appropriately. And you as a legislator who values public education, who believes in the schools in your community, who supports students, who wants to see continuous improvement in the quality of education, can understand the link between the courts and the decisions the court makes and your ability to rally enough people to get to 63 votes in the House to fund schools. We've got to swing enough people that way. And I think that as long as we're dependent on a system where the court has to intervene to say, fulfill your constitutional obligation to schools, there's a direct link between the court and a legislator's ability to meet the desires of his or her constituents. And you can make the argument around school issues. Education in Kansas is still the #1 issue for Kansas voters. That's what everybody's polling is showing this year in this election, that education is more important to our voters right now than jobs and the economy in Kansas. It's a hot button issue, and a legislator that wants to be reelected needs to meet that obligation. And one way to do that is to argue with them that this court issue is important, that merit selection is still important. That builds you and provides you the support to go ahead and do what you want to do, which is fund schools. And that meets your constituents' needs. And I think that's been helpful to me. I'm not going to argue it from an LGBT or Sierra Club or voter rights. That's not my argument. I've got other allies to make that argument with the legislators that are friendly there. The other part of that is that for 152 years, we've been working with teachers.
I like that.
Just wanted to point that out. And, you know, our teachers have been, they're concerned about their classrooms, their students in their classes, and they don't seem to be concerned about much else. It's very hard to get them politically motivated. But the way in which this governor and this legislature are pursuing their agenda, which includes eliminating merit selection, starts with direct, mean-spirited, really vicious attacks on the teachers of Kansas. They have, this governor signed a bill to prohibit teachers from contributing to a PAC through payroll deduction. This governor pushed a bill unsuccessfully, thank God, to eliminate collective bargaining. He has stripped teachers of their due process rights in Kansas. He has eliminated teacher licensure standards for math and science teachers. He's going after teachers in an attempt to crush and the union, give them no reason to join a union anymore. And, you know, it's sometimes we always say our best organizing tool, our best recruitment tool is a bad principal, a mean principal. Well, a mean governor and legislature is finally turning teachers into activists for a variety of reasons. We can now talk to teachers about merit selection of judges and link all these things together, and they get it, because the attacks on them, the attacks on their PAC, the attacks on public schools, the attacks on the justices are all one game. And it's actually become easier to talk to our members and engage them in this issue as well as classroom issues or school funding issues or other issues as well. So it's actually kind of helpful to us and is supporting us giving us support in new ways to organize and fight.
Well, that actually, I'm going to go to Elise and I'm going to ask her a question. I didn't tell her I was going to ask her. But, but, you know, on Friday there was an article on RH Reality Check that sort of suggested that the new frontier for the right is really the courts. And, you know, this is a panel, and we're we're representing a 501c3 organization, and one of the challenges, I think, is the response that we're putting out there is, you know, a good government response. We want fair and impartial courts. We want, we're not saying we want courts to decide our way. We're saying we want fair and impartial courts. And yet, you know, in this article, there's a woman from a pro-life group who's quoted basically saying, you know, we've won in the governor, we've won the legislature, and now we're going after the next level, which is the courts. And it seems in certain places, it's clear that's part of a strategy. And so I guess I ask you to comment on that and sort of how can we respond and how do we mobilize around that, or how do we take it on?
Yeah, I mean, I might take issue with the fact that it's a new strategy. There's actually a memo from the early 90s written by then Reagan administration counsel, someone you might have heard of, Justice Alito, about how you actually do away with Roe versus Wade by pursuing a joint legislative and legal strategy around it. So I think this is, we're waking up to the fact that the other side has actually won on this. You know, I think you hit the nail on the head a little bit, and it's something Kathy and I have certainly talked about. I would say two things. The first is what I talked about in my intro, which is accountability. The accountability campaigns that we've run, be it Michael Boggs or Judge Battalion in Nebraska. There was a judge in a civil court in New York who allowed into evidence the idea that a mother in a custody case was an unfit mother because she had chosen to terminate a pregnancy, and the outrage around that was obviously palpable. The idea that people want to see judges held accountable when they are abusing their position on the bench has been enormously successful for us in getting people to focus on the courts as a strategy that we need to pay attention to, in addition to the legislatures. And so, you know, we look at that to shine the light on these bad actors so that our base really understands that there is a third branch of government. It's a very interesting thing. In some cases, these accountability campaigns against these judges that we're talking about have actually garnered more engagement from the base than a lot of our traditional advocacy campaigns aimed at federal Congress. And I think we have to look at the fact that the confidence in federal Congress right now is at a historic all-time low. So as organizers, where are we asking people to put their time and energy when people have less time and energy to participate in the idea that we need a just and equal society? And what we found is that a lot of people believe that their calls to Congress go into a vacuum right now, but they do see a real potential outcome if we're asking a state ethics board in a court case against a judge to take action where a judge truly abused his position. So accountability is a really big one. The second one is we do have to, and I think Mark spoke to this, but we really do have to connect this to issues. We just absolutely have to, and it runs against a lot of our natural instincts on a number of different fronts, right? We have spent a long time believing that the courts are impartial and they're fair, and if we actually connect them to a specific issue that we will be violating our own principles, we've got to throw that out the window, because there's no way to engage people without making the court's decisions living, breathing things that in a way that affects lives. And the examples are out there, but we've kind of tied our hands behind our backs in doing so, because we have this idea that as liberals, we will just believe in this bright, shining court on the hill, and that will be enough to mobilize people. People are really busy. If we don't hit them in the gut or in the heart, it's really not, we're not gonna surface the potential majority in this country that actually is starting to see the courts as a very dangerous political tool for the other side. And you know, I always say the courts are important, but the decisions that they make are increasingly insidious. We're seeing this around admitting privileges for clinics, right? This is a fabricated, architected need in a lot of the state legislatures that abortion providers, unlike any other doctor, have to have admitting privileges to a hospital in case something goes terribly wrong. It's completely false. Emergency rooms will treat anyone who comes in, regardless of whether the doctor has admitting privileges, and particularly, you know, pre-viability abortions are among the safest medical procedures. But you know, these are insidious ways that this is being heard in the courts right now, that they are getting at it, and they're largely invisible, right? We're just not talking about it in a way that mobilizes people. And so we've got to be willing to say to sort of a intellectual elite, as organizers, we have to be allowed to do our jobs, right? We've got to be able to show people that the courts that we trust, particularly at a time where our trust in the federal Congress is so low, we've got to be able to show what's actually being done, that there is recourse. The recourse can be through accountability, or it can be through, you know, elections of either judges in states where they have elections or legislators where there's appointments. And we've also got to do it by connecting the issues. And, you know, I say this because I started with the 7 in 10. 7 in 10 Americans are pro-choice. Totally, we've done this polling nationally. We've done it in deep red states like South Carolina. When you ask the question about the rights enshrined in Roe, 7 in 10 Americans are pro-choice. 4 in 10 federal legislators are pro-choice. 3 in 10 governors are pro-choice. 1 in 10 state legislators are pro-choice. And that's where we are seeing the damage done, is this out of balance piece of it that goes because of voter suppression, that goes because of money in politics. And so, you know, while I will spend 90% of my time educating my constituency about the things that I know mobilize them, it is incumbent on me to spend 10% of that time connecting to the other issues that matter deeply if we are truly going to have a court system that does put the rule of law above a minority's ideology in this country.
And Mike, I'm going to go to you next. I know a lot of what you do and Eric and Raquel do is actually educate. You talk to your constituents, you tell them about what's going on, you tell them what's happening. Tell me a little bit about what you do. Tell me a little bit about your constituency, how you talk to them, where you talk to them, and what you tell them.
Well, let me just remind you that I am Mike Petro with the Committee for Economic Development. It's been so long since I've had a chance to chat with you all. Listen, I am the strangest of strange bedfellows at this. I mean,
And
this
we
is the elephant
appreciate
in the
you.
room. I'm it, okay? I represent a group of business leaders, 200 senior executives from across the country. I've been informed that I'm going to have to pay for my lunch later on this afternoon. That's how bad it is. Listen. We have a network of business leaders from across the country who care about this issue. I think I mentioned to you for the reasons why. But we issued a report in 2002, which has really been kind of the blueprint, if you will, for our strategy. It's called Justice for Hire. And essentially it calls for a merit selection or appointment system in the states in preference to elections. And you know, of course, we recognize in this report that that's not going to happen, especially in certain states where People have been electing their judges for decades. So we recognize that, and then we go beyond and recognize and recommend some reforms, which include public financing of elections. A business group, mainly of middle of the road, many of them Republicans, urged for public financing of elections because they saw this as a public good. They saw this as a difference between a member of Congress or a legislator who has to answer to his or her own constituents and a judge who needs to answer to the law. So they saw that difference, and I think that was significant. So what we do is we go around the country and we look for areas of opportunity, places where either reform is possible or where conversations are happening, and also where there are enlightened business groups, and they are all over the country. We find, for instance, that state and regional business groups and chambers are far more supportive of this issue than having a conversation here in Washington, which I would say would be a waste of time if you went to the National Chamber of Commerce. I see Lynn Marks over there from Pennsylvania. She's put together an impressive group of business people and business groups in support of reform in that state. And I had breakfast with Judge Katie this morning, and the business community there is very supportive. So what we do is we, as a national organization, identify places where reform is possible, and we connect that where there are business leaders and business groups that can be part of a larger coalition to support reform. I would add one other issue to this. A lot of our members got involved in this issue when they saw the paltry sum that we pay these justices from across the country. You know, business leaders, they get what you get what you pay for. That's the way they look at this issue, right? And so when they found out that Supreme Court justices in many of the states could barely eke out a living, they were appalled by that. So I guess there's a variety of ways to engage these stranger than strange bedfellows, but I would say you've got to do it. We have to reach beyond just some of the people that are here at this conference, because there are ways to talk to business people and others, and I would say Republicans and moderates. The far right is a lost cause, we get that. But there are other people out there who are more rational and who have thoughtful views, and being able to speak to them and bringing them to the table is critically important.
And for Lambda Legal, we are a litigation shop. I am an attorney, but we do have community educators who understand how to communicate and connect the issues that we care about, our view of the Constitution, and who it's designed to protect, to regular communities, to talk to people and explain these decisions and how legal issues impact people's daily lives. And I think what we try to do with the Fair Courts Project is rely on strong state organizations that know their constituencies, that know how to do grassroots organizing, that know how to do education, and to connect these issues. Groups, I'm looking at Donna Redwing from Iowa here, Connie Ryan Terrell from Justice Not Politics, folks who have their fingers on the pulse of their constituency and can explain and engage with people. And then the other thing I'm struck by is how much there's a need for cross-movement, cross-issue communication about why fair courts matter. Mm-hmm. Because this is an attack not on a particular issue. It cuts across all issues. And I'll give one example, which was in New Jersey. And I have a different view of the selection system in New Jersey than my friend from Kansas did. They actually have a pretty good system where judges just come up for a reappointment process, and then once the governor reappoints, they have tenure. So it frees them up to make unpopular decisions that are in the best interest of the people, of all of the people. But Governor Christie was systematically removing, through the reappointment process, judges that he disagreed with on particular decisions. And there was, right after our marriage case there, and we got a good decision from the state Supreme Court, there was an article by the Washington Post by Jonathan Capehart that said, look for Governor Christie to replace gay marriage judge. And he didn't just use that issue, but he used issues about equal access to education financing, about affordable housing that the Constitution in New Jersey protects, human rights decisions, that we had to if we were going to build a base to talk about this and organize, we had to do it across issue areas. So we worked on working with workers, with teachers, with students, with the NAACP there, with the ACLU, with the League of Women Voters, to put together a campaign that would have a video component or a messaging component, that would have a petition-based component, that would also demand accountability from the governor, not to politicize the system. We had a protest, a Fair Courts protest, not too many of those around the country, outside the Superior Court, folks demanding fair courts now.
When do we want him? No.
Right. And
That's what I do. I do chanting and stuff.
we need you to come up with a few more. Governor Christie, don't you dare, we demand our courts stay fair. That's catchy. Politicizing the courts is a bridge too far. But at any rate, Governor Christie reappointed the Chief Justice because of this pressure, but recognized when he just went to Iowa 2 weeks ago, the Judicial Crisis Network dumped $60,000 into that visit to say, in a campaign called Bad on Judges. And all they had to say was he let liberal activist judges remain on the court, and their constituency gets it, and they're energized, and it was an instant attack. We have to do the grassroots organizing of explaining, of energizing our constituency, because frankly, we don't have that kind of money. And we can't just say, we don't have these buzzwords, and we shouldn't rely on them, like judicial activism, to engage our constituency. But we have to have a framework to talk about these issues that does connect the issues with the fair courts that we care about and our view of the Constitution. But we have to do it with state groups, and we have 143 potential new partners, so I'm excited about this organizing opportunity and do it across issues.
So Raquel, you
All
do
right.
that, I imagine. Talk to activists about this, and what do you
Right.
say?
So we believe as Mi Familia Vota, we're part of one of coalitions. And we can't do the work on our, by ourselves, and we understand that we're not the experts either. But we do knock on doors, we do have conversations with voters. Right now we're focusing on the rising American electorate. So we're talking to Latinos, we're talking to youth, we're talking to single women without a male in the household. And the LGBT community. So we are reaching out to voters. So our role is like, how can we educate them on this issue? So we look to partnering with, like, for example, Arizona Advocacy Network and other national organizations to educate our community on how the process works, and then also how people can be involved. And the merit system, for example, there's a commission to select the commissioners. So all these all this process are very important. So for us, we are looking at doing community forums like through this year and next year, and starting to engage more people in this issue.
Great.
But it's precisely on the voters that we target.
Great. So I actually think it's time to go to you guys and spend a little time with you figuring out a question we have, which is, if the financial and human resources were not a constraint, what is it you would invest in? What would you do to expand the constituency that you're working with on this issue? I think it's up there. If financial and human resources were not an obstacle, how would you invest to expand and strengthen the impact of your coalition working on state court issues? What would the 3 to 5 most important investments or activities be? And I'm going to ask you to try to work in your table group. And I see a couple tables where there's maybe 1 or 2 people. If maybe you could join the table near you and do that. And we're going to give you 10 minutes for you to have that conversation. And then we're going to ask you for some feedback and ask these folks for some feedback on your feedback. Because so far you've gotten off a little bit easy and haven't had to do too much work. We're against that. We want you all to be working hard. Thank you. 10 minutes.